At this point I will look at some existing laws and regulations, and consider the extent to which they follow the principles I have elucidated. Well, if the primary purpose of law is to protect people, then as a minimum there will be a basic and limited set of laws, intended only to protect people's persons and property rights. In particular, there will be laws against murder, rape, and assault, and laws against stealing other people's possessions, obtaining them by deception, or damaging them. These basic laws do in fact exist. And I approve. But many other laws exist, and I contend that at least some of these other laws are undesirable. To start, there are a number of laws which have the purpose of protecting me from myself. For example, laws requiring me to wear a seatbelt, laws requiring me to wear a helmet if I ride a motorcycle, and laws forbidding me to take certain drugs. These laws do not protect me from others. After all, no one is trying to force me to drive at speed without a seatbelt, or to take drugs. And, if someone did try to physically coerce me into doing so, that would be assault, which is illegal anyway. And these laws do not protect others from me. After all, if I choose not to wear a motorcycle helmet, and then I am involved in a motorcycle accident, the only person I am putting at risk is myself. These laws therefore appear to be entirely unnecessary. Is it possible to defend them? Well, you might argue that some of these laws ensure that I can access protection that would not otherwise be available to me. So, for example, in the absence of a law requiring car manufacturers to fit seatbelts, my car might not have a seatbelt, and so I would be unable to access the protection that a seatbelt provides. This argument has some validity. However, once all cars are required to have seatbelts, if I want to wear a seatbelt, I can. Requiring me to wear a seatbelt not only takes that choice away from me, it requires me to pay additional tax in order to meet the cost of enforcing this law. I am therefore being forced to pay money to the government, so that the government can forcibly prevent me from doing something which harms nobody other than myself, and which I could in any case choose not to do. This law is not necessary. You might say that such laws are in fact necessary, because, without the threat of legal sanction, people will make bad decisions. Well, firstly, do you mean bad decisions, or decisions that are different to those that you would make? People are all different, have different beliefs, and different priorities. They therefore make different decisions. Just because someone makes a decision that you don't understand, do you have to forcibly restrain them from doing so? Let's assume that you really believe that people are making wholly unjustifiable and ridiculous decisions, and must be saved from themselves. If so, you are arguing that those members of the electorate are incapable of thinking and acting reasonably. If you believe that to be the case, surely those people should not have the vote. Why would you let such irrational people have any say in making the laws that will apply to you and everyone else? If this is the case, then the first step for the government will be to review the rules over who gets to vote, not fiddle around with relatively minor laws about seatbelts. Once the government has decided which people are considered incapable of making reasonable informed decisions, and has removed their voting rights, it might then consider whether to protect them from themselves, for example, by prohibiting them from smoking, or requiring them to wear a seatbelt if traveling by car. But these restrictions would not be applied to voters. You might argue that saving lives is so important that it justifies the government imposing protective behaviors upon us. But, if we take that argument to its logical conclusion, then we would all be required by law to eat a specified diet and take a specified amount of exercise. Potentially dangerous activities such as driving, cycling, and rock climbing would be banned. Ultimately, this would lead to a world where people are told what to do, every moment of every day, for their own good. So, accepting a principle that it is reasonable to restrict people's choices, because some choices may increase the risk of a bad outcome for the person making the choice, sets off down a road that would lead to denying people the freedom to make any choices at all. You might argue that these laws are not designed to protect people from themselves, but to protect other people from financial costs, physical harm, or emotional damage resulting from the forbidden behavior. But these arguments are questionable. Consider drugs. You may argue that taking drugs leads to other crime, which will cause financial, emotional, and possibly even physical damage to people other than the drug user. But, at an individual level, each drug taker has a choice as to whether they commit these other crimes, or not. The drug taking and the other crimes are distinct, and legalizing drugs would not legalize the other crimes. An effective law and order system will deter people from committing those other crimes by catching and imprisoning the perpetrators. The law and order system would be more able to do this if police officers did not have to spend time enforcing drug laws. I note in passing a fallacious argument when it is argued that drug takers convicted of e.g. burglary should be sentenced more leniently, as they had to commit the crime to feed their drug habit. This seems rather like a drunk driver arguing that she should have a reduced punishment for running someone over, because she was drunk and therefore out of control. Drug users are drug users by choice. Even drug addicts are taking drugs through choice. To become addicted to a drug, you have to take that drug regularly, over a period of time. And that is a choice that you have made. If drug users have chosen to develop a habit that can only be financed by stealing, that does not absolve them of responsibility for stealing. If anything, it makes them more responsible. Again, using drugs can change your personality, behavior, and ultimately kill you. So, yes, drug users are choosing to act in ways that ultimately may well be extremely distressing for their family and friends. In the same way, I may know that if I dump my girlfriend, that will be distressing for her. But that does not mean that there should be a law that prevents me from ending that relationship. You might argue that drug users do not understand the effect that taking drugs can have on them. I disagree. It seems to me that the risks of drug taking have been extensively publicized. But, if you did think this was the case, then surely government money would be better spent on educating people about drugs, rather than trying to find and punish those who choose to take them anyway. To turn back to seatbelt legislation, the situation where not wearing a seatbelt puts others physically at risk is a head-on collision, when someone in the back seat, who is not wearing a seatbelt, comes flying forward and kills someone in the front seat. Someone in the front seat not wearing a seatbelt will fly through the windscreen, and is likely to suffer significant damage, but this is unlikely to hurt anybody else. If the seatbelt law is designed to protect others from physical harm, then logic demands that it would require seatbelts to be worn in the back seat, rather than the front seats. This is the opposite to what was required when seatbelt laws were initially introduced into the UK. So, if the law was intended to reduce injury to people other than the seatbelt wearer, it was a very badly designed law. I now turn to employment legislation. There is a multitude of laws that govern the employer-employee relationship. These cover things like the minimum wage, working hours, entitlement to holidays, parental leave, redundancy rights, and many other things. These laws are detailed, and complying with them is challenging. Are they necessary, and if so, do they have to be so extensive? In a society where the alternative to being in employment is starvation, laws protecting workers are necessary. If I have to accept the employment terms that are offered to me, or starve, then I will accept the terms, no matter how unreasonable they are. This was the case early in the Industrial Revolution. However, this is not the case in modern societies, which provide benefits to those who are out of work. On the assumption that these benefits provide an adequate safety net, which is currently debatable, but could be achieved, then there is no necessity to accept a particular job. Remaining on benefits, while it does not provide a life of luxury, is then always a viable option. So, given an adequate benefit system, the argument that legal requirements regarding employment terms and conditions are necessary to protect workers falls away. After all, each job is different, and different employers and employees will each want different things, and a one-size-fits-all solution is therefore unlikely to be optimal. In the absence of employment laws, employees and employers can negotiate appropriate contracts between themselves, and therefore agree whatever best suits them both, without government imposing an outcome that neither of them wants. So, for example, if I am not planning to have any children in future, I may be happy to accept a job that does not offer parental leave, maybe in exchange for slightly higher pay. Admittedly, if I change my mind, or the unexpected occurs, then I may have to try to renegotiate my contract of employment, or change jobs. But major life changes often require that in any case. Similarly, if a job is very convenient for me, or involves something I love to do, I may be prepared to do it for less than the minimum wage. As long as I have a viable alternative, this is not a matter of employer exploitation. It is a matter of personal choice. If an employer is offering terms that no one is prepared to accept, then, if it needs employees, it will have to think again. If I find that no one is prepared to offer me employment on the terms I want, then, if I want a job, I will have to reconsider what I consider acceptable. This balance between employees and employers will result in equitable outcomes. You may argue that, in practice, the idea that everyone will negotiate their own bespoke contract of employment is not realistic. And it is not. There are clear advantages for employers in having standard contracts that apply to everyone, as it makes communicating with employees easier, and standard processes can be put in place to deal with common events. However, having more flexibility as to what is in that standard contract is still beneficial. Employees, or their representatives, and individual employers, can then negotiate standard contracts with terms that are best suited to the particular nature and circumstances of each employer's workforce. And, in smaller firms, the flexibility might very well be used at an individual level. If a firm employs 1,000 people, the human resources department probably doesn't have the slightest idea who Janice in accounts is, or what her specific circumstances are. But, in a firm employing 10 people, everyone will know who Janice is, and that she has a special arrangement. You may argue that employees don't understand employment contracts, and current employment laws, therefore provide protection against employees inadvertently accepting outrageous contract terms. But, by signing a contract, an employee is explicitly taking on several onerous obligations. Anyone who wants to keep these commitments that they have made will need to understand what the job requires of them. Even under the current legislation, if an employment contract is written in such obscure terms that the person signing it doesn't understand what the job requires of them and what their pay and benefits will be, why would that person sign it? The remedy for a lack of understanding is surely that contracts should be kept as simple as possible and written in plain English. I note in this context that the value of a legal contract often seems to be assessed on the basis of how long it is and how many subclauses it contains. This is nonsensical. Any legal document should be drafted as simply, clearly, and concisely as possible. A well-drafted legal document will never need to be tested in court, as it will be clear to all parties exactly what it means. If parties end up in court arguing about a legal document, while this may mean large fees for the parties' respective legal advisors, it reflects very badly on the lawyers who drafted it. You may argue that employees do not have enough knowledge of standard terms and conditions in the market to fully assess how a proposed contract compares to typical market practice. There may be some validity in this argument, although most people will have some experience of what other jobs offer, or will know people who have such experience, or can access it, e.g. through trades unions. I suppose that there is a potential role here for government, in that it could produce example contracts, based on the government's view of standard practice. I have no great objection to cost-effective provision of information, indeed this can sometimes be helpful. What I most object to is compulsion, when it serves no useful purpose. I now turn to health and safety legislation. There is a lot of this legislation, which is designed to keep people safe. This generally falls into two categories: legislation designed to protect people at work, and legislation designed to protect the general public. Often this legislation is extensive, detailed, and prescriptive. Organizations may need legal advice to understand what is required of them, and complying can be time-consuming and costly. In many cases, compliance appears to be nothing but an onerous tick-box exercise. Thus, much health and safety legislation goes against the principles that laws should be few, and that when laws are needed they should be simple. This raises questions such as whether health and safety legislation in its current form is necessary, and whether there are other ways to protect people. An example of UK legislation that relates to safety at work is the working at height regulations. These cover, for example, the use of ladders. They require that, before a worker climbs a ladder, alternative means of access should be considered, and a risk assessment should be completed. A ladder can only be used if there is no practical alternative, and if the risk of using a ladder is assessed to be low. There are detailed regulations regarding how ladders should be positioned and secured. Ladders should be regularly inspected, and these inspections should be recorded. I question whether this legislation is necessary. This legislation is designed to protect me if I climb a ladder at work. Now, assessing whether a ladder is safe to climb is not rocket science. If I climb a ladder without considering whether it is safe to do so, or assess a ladder as unsafe, and decide to climb it anyway, and have an accident, that is a choice that I have made, and I only have myself to blame. The law does not increase the level of protection available to me. I can already protect myself by assessing the situation, and deciding not to climb the ladder. On this basis, the law is not needed. You might argue that the purpose of the regulations is not to prevent me from choosing to climb precariously balanced, rotten ladders, but to prevent my employer from forcing me to climb them. The first point to make is that if my employer is asking me to do something that I consider dangerous, then I can always refuse to do it. That may of course lose me my job. But, if the government provides an adequate benefit safety net, then, as I previously discussed, not having a job is a real option. In practice though, losing my job would very much be a worst-case outcome. Most employers would not fire an employee for raising a health and safety issue. Indeed, I would not want to work for an employer who acted that way. Instead, if I raised such an issue, I would expect to have a discussion with my employer about an appropriate level of safety equipment and other protections to be used. You may say that is all very well if I am being asked to climb an obviously rotten, unsecured ladder, but there may also be cases where I am asked to perform a task, or use equipment, that I am not aware is dangerous. This is a fair point. It can be addressed by requiring employers to inform employees of significant risks that the employer is aware of, but that the employee may not be. This is a straightforward principle that can easily be captured in a simple law. Armed with this information, I will in many cases be able to assess the risk and have a discussion with my employer about how best to proceed. A single piece of simple principles-based legislation could therefore replace many of the detailed regulations that are currently in place relating to particular areas. However, in some cases additional legislation might still be required. For example, the majority of employees will not be in a position to make a reasonable assessment of the risks involved in working with radioactive substances. In circumstances such as these, legislation might therefore require formal risk assessments to be performed and documented. This differs from situations where the risks are clear and well understood by employees, for example, climbing a ladder or considering whether to wear a hard hat on a building site. In reality, most employers will not want their employees to be injured at work because they care about their employees, because of the disruption to their business if employees end up dead or in hospital, and because of the reputational damage. So, in practice, in the absence of the current legislation, many employers might, of their own accord, set internal rules about things like the use of ladders, and write into contracts of employment that these should be followed by their employees. Rather than being imposed and enforced by the state, safety at work would then become something for employers and employees to agree between themselves. And, to facilitate this, if the regulations were reformulated as an example of possible practice, some employers and employees might even find them to be useful. The other general area of health and safety regulation is that designed to protect the general public. This might, for example, relate to food hygiene, safety standards, and clear labeling of products that may be dangerous. How do I think legislation might deal with these areas? Now, I cannot make informed and reasonable decisions unless I am in possession of the relevant information. So, for example, requiring poisonous substances to be labeled as such, or requiring foodstuffs to state if they contain potential allergens, or at least labeling that they cannot be guaranteed to be free from them, is reasonable. Again, however, it may be that this principle could be encapsulated in a single high-level piece of legislation, rather than in a multitude of individual regulations. There also needs to be a level of proportionality. If your business involves getting up every morning, making a tray of assorted sandwiches, and then going around local workplaces and selling them, then it might be reasonable to expect you to label each sandwich with its constituents, for example, white bread, butter, salami, mustard, and tomato. But I do not consider that it would be reasonable to require those labels to also set out all of the ingredients in each of the constituents that you have sourced, because the time and effort you would have to spend to do so would be disproportionate to the value gained by the consumers of your sandwiches. Neither, in my view, would it be reasonable to require you, for example, to specify how much salt each sandwich contains, or its calorific content. This is not information that you will know, or that you can easily obtain. Now, if you choose not to label your sandwiches in detail, then this means that people with certain allergies, or who are very careful about what they eat, may choose not to buy your sandwiches. You will lose some customers who can source their lunch elsewhere. What about the hygiene and other standards that might apply when you are making, wrapping, and transporting your sandwiches? Now, you are selling your sandwiches for people to eat for their lunch. Regardless of your hygiene practices, if your sandwiches make people sick, or are otherwise contaminated, then they are not fit for purpose. If you sell contaminated sandwiches to people, you are therefore obtaining their money by deception. This is fraud. If your sandwiches are not fit for purpose, even if your hygiene practices are perfect, you have committed a crime. So, the authorities might have a system of random testing, where from time to time they buy one of your sandwiches and subject it to analysis. And, of course, if someone becomes ill after eating one of your sandwiches, they might complain to the authorities about this. As a result, some of your sandwiches could be seized and tested. In either case, if testing identifies that you are selling contaminated sandwiches, then you have committed an offense and would be prosecuted. The key point is that the offense is selling contaminated sandwiches, not whether or not you have complied with pages and pages of detailed hygiene regulations. Now, this does not mean that you can ignore hygienic practices when preparing your sandwiches. If you do so, it is likely that when tested, your sandwiches will prove to be contaminated. So, you are still motivated to follow hygienic practices. You may even wish to document them, so that, should you be identified as a purveyor of contaminated sandwiches, you can provide evidence that you have taken reasonable steps to prevent such contamination, and contend that you should therefore not be punished. Now, you might argue that, as a responsible business owner, you would of course follow best practice. But what about rogue businesses? In the absence of detailed regulations, how can the authorities close such businesses down before they poison anybody? Well, in the same way as they do currently, by inspecting them. It is just that the inspection would be of the product, to ensure that it is fit for human consumption, rather than of every single detail of how it has been prepared. This is also an area where local government may wish to introduce supplementary legislation. If a particular area has a problem with fly-by-night food retailers poisoning the local population, it may wish to increase levels of random testing, or even impose more stringent regulations on such businesses, funding the cost of policing these by raising local taxes. So, the approach I have outlined, focusing regulation on the safety of what is sold, rather than how it is produced, would avoid imposing detailed regulations, with their associated costs and constraints, on businesses, but would nonetheless encourage good practice. And, if particular issues arise in particular areas, these can be addressed locally. I have talked about the safety of consumers of products. But what if the production of goods has wider negative implications, for example by polluting the environment? Well, in general terms, if I am doing things that damage other people's persons or property, then the law should punish me. So, focusing legislation on outcomes, rather than the processes leading to them, would also work here. Another example is government regulation of how financial products are communicated to customers. If I am buying a financial product, then I need to know how it works, what the risks are, how much I will be paying in commission and fees, and so on. Without this information, I cannot make an informed decision. Current disclosure requirements, for example in relation to pensions, seek to achieve this by setting out every single piece of information that has to be disclosed, how it should be presented, and when and how often it should be provided to customers. The result is that to reduce the risk of being sued, providers focus on producing documents that may be completely incomprehensible, but meet all these detailed requirements, rather than on producing documents that customers can actually read and understand. If these regulations were swept away, and replaced with a simple requirement to provide significant and relevant information to potential customers, in a comprehensible format, then the focus would be on communicating the relevant facts, and if a customer claimed that the information was misleading, or omitted material relevant facts, then a jury could read it, and reach a judgment on whether this was actually the case. There are many areas where the need for legislation can be questioned. Many governments have passed laws against bribery. Guidance issued by the Ministry of Justice in the UK, on the Bribery Act 2010, broadly defines bribery as giving someone a financial or other advantage to encourage that person to perform their functions or activities improperly, or to reward the person for having already done so. It then provides an example. This could cover seeking to influence a decision maker, by giving some kind of extra benefit to that decision maker. Is this legislation needed? Are there any circumstances where bribery might reasonably be legal? One point is clear. The logic of democracy requires that it should be illegal for government officials to solicit, or accept, bribes. If I have to make additional payments to benefit from law enforcement and other government services, if these services can be bought or sold, then my legal rights will not be the same as yours. They will depend on what each of us can afford to pay. What about private organizations? Suppose I own a business, and a prospective supplier takes me on an all-expenses-paid trip to the European Cup final. Maybe they also suggest that if my business switches supplier to them, then they will take me again next year. Well, if I own the business, then it is my property. The law is there to protect my property rights, which include the right to decide which suppliers that business uses. If I choose bad or expensive suppliers, because they have taken me to the European Cup final, and my business suffers as a result, I will lose money. That is my choice. The anti-bribery law does not provide any additional protection for my property. In the absence of anti-bribery legislation, I do not have to accept bribes. So, in this case, the legislation is not needed. You may argue that that is all very well for me, but, as a result of my decisions, my employees may lose their jobs. But, that is true of any decisions that I make about the running of the business. If it is my business, then the logic of property rights implies that those are my decisions to make. What if I own the business, and the business employs you, to make decisions about which suppliers to use? Suppose that, rather than taking me, the substandard supplier takes you, to the European Cup final. Further, suppose that you subsequently award a contract to that substandard supplier, despite there being companies in the market who would do a better job. Now, that is a pretty clear case of bribery. But is it really a matter that needs government intervention? The remedy is surely for me to sack you, and maybe sue you for the financial damage that your actions have caused to me. And, to facilitate this, a well-run business will ensure that contracts of employment are robust, that sensible procurement policies are in place, and that higher authorization is required for significant decisions. As a remedy already exists, legislation is unnecessary. At the end of the day, business works on the basis of commercial transactions. As long as bribes, or gifts, or whatever you want to call them, are properly documented, and subject to relevant taxes, I fail to see any real distinction between them and other business transactions. And the fact of the matter is, that people do business with people. Corporate entertainment allows people to get to know each other, size each other up, and build trust. An offering that looks great on paper can be disastrous in practice if the relationships between the parties do not work. Discouraging the building of relationships because people are afraid that they will fall foul of anti-bribery legislation is therefore counterproductive. I also note that similar arguments apply to nepotism. If I own a business and choose to give jobs to, or do business with, my family and friends, or other people that I know and trust, or indeed anyone I may choose, for any reason whatsoever, then why should the law prevent me from doing so?